Okay, the next case will be MARINI versus KELLETT.
Good morning, Your Honors. Mark Skipper on behalf of the petitioner or the appellant, Grace Marini, and I would like to reserve 5 minutes rebuttal time if necessary.
All right, you may proceed.
I've been under the weather all week, so hopefully my voice holds up. Your Honors, this is an appeal of a final judgment of paternity. In this matter, in our brief, we addressed 4 issues that we believe the court should reconsider that the trial court erred in. The trial court in this case allowed the mother to relocate to North Carolina, which we believe is supported by the evidence. However, the court established a time-sharing schedule that we believe was an abuse of discretion. We have a young child in this case be flying way too many times between North Carolina and Florida, causing an extreme hardship financially.
This is about the one thing y'all agree on, right?
Correct, Your Honor.
But even though y'all agree, y'all have not been able to work it out.
Correct, Your Honor.
So the judge has to do something.
We believe so, yes, Your Honor. And I believe even my distinguished opposing counsel stated that, look, this is a hardship on him. Neither party, he's not a millionaire judge, and so that, you know, we believe that it's a hardship on the child to be traveling this much time. And so, yeah, we did agree on, you know, we did propose a alternate time-sharing schedule, which was during the temporary relocation time period, which we believe enabled the father to have time sharing with the child and maintain a substantial amount of involvement and contact with the child that they were doing on the temporary basis. But ultimately, the court did not go with that temporary time sharing schedule that had been put into place and fashioned a new and different one, even after it was brought to her attention after the initial hearing. That judge just is not in the best interest of the child to be traveling this much.
So there's 3 schedules. There's the schedule until the child's 5, then from the time the child turns 5 to starting kindergarten.
Yes.
And then a new schedule.
Yes.
The child was born in 2014, so we're either there or close to being there with the 5.
Right.
Okay, and at age 5, it's 3 trips from North Carolina to Florida every month.
Right. I mean, I think it's a substantial amount of traveling for this child. It's a burden on the child and on the parents.
And after kindergarten, it's still 3, but it's shorter time period.
Right.
Now, is the summer split 50-50?
I don't remember, Your Honors, to be completely honest. So, I
think it was.
I think
that's
it was.
Usually where most judges
Right.
come up with, you know, when you have parents living far apart, they give the one parent with less time more time over the summer to reduce the amount of travel during the.
Right.
Was that idea proposed to the trial court?
I don't remember, Judge. I think so. I think that's the 50. I think the court did do a substantial amount of time in the summer's time to eliminate the need for the travel. And Judge, we also believe that the trial court, you know, did the.
Let me just, before we go off of that, what is it that you want us to do? I mean, you guys couldn't come up with you both agree this stinks. You couldn't agree on something. You don't like what the judge did. What is it that you propose that we do?
Judge, I think it should be remanded for the court to come up with a new time-sharing schedule that is.
Basically, all we're supposed to do is to say that was a swing and a miss, take another pitch.
Judge, I don't think this court's necessarily in a position to say this is what the new time-sharing schedule should be. You know, I mean, by the time it gets remanded, you know, circumstances may have changed and whatnot as far as what the travel schedule should be, as far as, you know, how old the child is, as Judge Evander said, you know, as far as school, you know, so I think that it definitely needs to be reversed for the court to come up with a new schedule, that this schedule is not working.
And what guidance do we give the trial court? If you were writing the opinion, what would you say?
I would say that, taking into account the age of the child, the amount of traveling that the child is going to have to be, the financial cost to the parties of all this traveling, not just of the cost of buying the airline tickets, the cost of missing work. If they have to get a hotel room, all of those things need to be.
Right, and I think what Judge Orfinger's getting at is the same thing I was. And Judge, here's what you ought to do. Here's something that is workable, it's reasonable, and that's why, if we just go down there and say, try it again and complain about what you got now and be reasonable, what are you going to do instead? You get Thursday till Sunday, you're not going to be happy with that.
Right. Well, we did put forth a proposal for the time-sharing schedule that was on the temporary relocation, which we thought worked.
But Dad didn't agree with it.
Right. And, right now, it's clearly not, we agree it's clearly not working, and it was not working for the child and not working for the parties.
Parties have spent somewhere well over $100,000 collectively on attorney's fees, and they're going to, if they go back and have the judge figure it all out again, and takes nearly as long again, the kid will have a driver's license and nobody will have any money or a job, right?
I understand what the court is saying, but I think if remanded, you got time that, the child will obviously be older than the child was at this time, and as far as taking into account school considerations, but in the meantime, we're stuck with this schedule that is not working for the parties, and that they agree is not working for the child, is not beneficial for the child, with an alternate time-sharing schedule that was put forth on a temporary basis that was working. Your Honors, the trial court also changed the child's last name. We believe that there was not sufficient evidence. The court abused its discretion for that. The father failed to meet his burden, and that his reason for wanting the child's last name changed was, to have a connection to me and have my last name. There was no evidence of any detriment to the child by keeping the child's current name. Mother was sole custodian under the law. They were not married at the time, obviously, and she had the right to pick the child's last name. There was no evidence whatsoever of any detriment to the child. In fact, the court said, because he had to go to court to get his time-sharing rights, which is what the proper procedure is under the law when you're not married and you have a child together, that's the reason, and because he wanted to be involved, that's the reason why I'm changing the child's last name. There's absolutely no findings whatsoever of any detriment to the child in that regard. So the trial court's order should be reversed with instructions to restore the child's last name to that of the mother, which the child was born with.
Is the mother's last name still what it was? I thought she remarried.
She remarried, but I believe she kept her same last name, Your Honor. And Judge, we also we believe that the trial court erred in awarding attorney's fees to the father. First of all, there was no finding whatsoever of any need and ability to pay by the trial court in this matter. It was raised on more than one occasion to the trial court, stating that it's mandatory to make the finding of need and ability to pay.
Can we make that determination if we have evidence of the father's income, evidence of the father's asset, and evidence of the father's attorney fee obligation to his attorney?
Well, the trial court requires...
in other words, if we send it back for that purpose, is it just going to be something the judge takes 5 seconds and says there's a need?
Well, even if that, so we believe that there wasn't a need. Even if you say that, okay, the findings weren't there, there was no need on the father's behalf. He clearly had the money to hire his own counsel. There's no evidence of any financial detriment that he went into debt to fund this litigation. The evidence was he sold a house below market value. He basically flipped it, and he could have earned more that way. He had a wedding, took a honeymoon, took a ski trip, gave money to other relatives. So he clearly had the ability to pay. There was no need.
Was there testimony about whether he still owed money to his attorney at the time of trial?
As far as whether, I'm sorry, Your Honor?
Whether he still owed money to his attorney at the time of trial?
I believe so, Your Honor, but to be honest, I don't remember 100%.
Okay.
But the father had voluntary expenses, so even if the court says, okay, well, you didn't make the proper findings, which are required under the statute, And it was raised in a motion for rehearing. It was raised at the when the trial court entered the one order, and she said, "Well, I can just go ahead and enter that in the final judgment." And that wasn't done at that point either. So even if that you say, okay, well, all she has to do is make the finding. There was no evidence of any need on the behalf of the father in this case. And then finally, we believe that the trial court inappropriately calculated the child support in this matter, and that, for one, it took the gross income of the mother, not the net income. We laid out in our brief numerous instances of inappropriate calculations that we believe were done by the trial court when there was no child support guidelines worksheet. There's no way to determine how she came up with this number of the child support. The child support calculations didn't inappropriately designated as far as the taxes for the calculations, did not include mother's state income taxes in North Carolina, didn't calculate to her net income, just used her gross income, and there's basically no way to determine how the trial court arrived at this number for child support. And then her verbal ruling did not match the final judgment, didn't include her health care costs. So there are numerous different reasons for this child
I
support.
think it was appropriate for the trial judge to impute income, since your client had the opportunity to earn, at least initially, almost twice as much if she worked full-time rather than part-time?
I think that I would say no, because to testify as far as what she was earning, making, she was working. It's not somebody who was working part-time, making minimum wage, working part-time. She was making a substantial amount working at her job, and then she had a part-time job. She had that one job, then she had another job managing property. So in essence, she was working a full-time job between what she was doing, between the one regular job and the other job managing the property. So she was working full-time for at least 40 hours a week. It's not somebody that was employed half the time, working 20 hours a week at one place and at minimum wage, not earning any other monies. The court has any other questions? I'll just reserve the balance of my time then.
Okay, thank you.
Thank you, Judge.
Your Honors, my name is John Baldwin. I'm here on behalf of the respondent. I've got this problem. I just had eye surgery. I'm an old guy, and I just had this eye surgery, and I don't know how to use these. I don't know how to transfer from using glasses all my life to not glasses and then these darn reading glasses. So I can see you fine right now. I can't see this worth a darn, so I'm learning. So these are $5 glasses from Walmart, and they don't worth a darn. Okay.
If you can get that whipped, then everything else is taken care of, right?
I kind of think that.
Okay.
I go back to my old glasses, the way I look at it. I grew up with them, so not a big deal. There's a part here that I emphasize. I wrote a longer statement of facts in here than I've ever written in any brief in my career. Because I think the total picture is what is here, is what brings this case together.
Let's assume the mom was, as you argue in your brief, really bad about. Let's assume, as you argued in your brief, that the mom was really bad about letting the father see the child until you brought the action. So
yes.
Let's use that as a given. But we have a situation here where this child is supposed to travel 3 times a month from North Carolina to Florida. And, do you think that stinks too?
Yeah.
Okay.
Try to say otherwise, but
right,
we're
so-
on appeal. As I emphasized, I wrote a whole 2-3 pages here on abuse of discretion, the standard, and that's the standard, and that's what you're faced with. And it's just like Judge Orfinger was saying, what do you think we're supposed to do here? That's not what we're not supposed to be ruling on facts.
we do look at whether the trial court had an obligation to act in the child's best interest.
You don't have,
For instance, if the trial court said there's going to be every single day, every other day the child is supposed to fly, we could say abuse of discretion, right? If there were 15 visits to Florida a month?
to apply the standard, I don't think you do. if you apply the standard that's in Severs and Canacris, and if you really read this abuse of discretion standard, discretion in this sense is abused when the judicial action is arbitrary, fancy, or unreasonable, which is another way of saying that discretion is used only where no reasonable man would take the view adopted by the trial court. That's not the case here,
So
and I don't think...
Just so I'm clear, are you saying that you're okay with the travel schedule the way it is?
I think you have... You don't know the situation of the alternatives, because, I mean, you're not privy to what people say, so you don't know, but every time...
Simple question.
Yeah.
You're okay. If we affirm the travel schedule, you're telling us you're okay with that?
What I
'Cause
think...
I got the sense from the briefs was that you weren't okay with it.
What
Because
I
your
said
client
was, this
having
is
to miss
evidence...
work.
This woman's primary statement in her brief is, I don't have the money. She's worth $1 million, he's worth $30,000. If you don't have the money, ma'am, you're the woman that moved to North Carolina after going 16 months without having the father have any time with the child, okay, any significant time, and you moved immediately with the child on temporary, which established a predicate in the case of, oh, he's already lived up there 2 more years or a year
Can we
or
circle
something.
back to my question?
Yeah.
My
Yes, sir.
question was, are you saying that you're okay with the time schedule the way it is? Because my impression was that your client was saying that this caused him to lose days from work every week of the month, and that it was hard on the child to be moving back and forth this month. So
Yes.
are you telling us that you want us to affirm the time sharing, or you don't want us to?
Later on in my brief, I say that it was wrong to allow her to relocate. If she has the $1 million and she's complaining about it, it's wrong to relocate, and what I suggest in my brief is undo the relocation.
Let's try to take it in bits and pieces, though. If you don't win on the relocation, and I'm not suggesting that you will or you won't, but if you don't win, what is your position on the time sharing?
I don't like the time sharing, but it's not an appellate issue. It is no abuse of discretion here. You do not rise to that standard, and it's not your place to do it. And what will happen, I try to read ahead what will happen in a case. People start all of a sudden coming to realize what's really best for this child, and they stop making demands. I want more time with the child. I mean, my client never had meaningful time until the child moved to North Carolina, and you took him away, and then you took him away right off. Now, okay,
But
forget the relocation.
when does it become unreasonable? Like I said, what if the child is traveling 15 times a month from North Carolina to Florida? Are you saying that as an appellate court, we could not say that as a matter of law that's unreasonable?
I think you can.
Okay.
On the example you just gave,
All right.
yes.
Well, I will tell you, having, been in family division for years and having been up here for 13 years, I have never seen a final judgment with 3 times a month for a young child to travel between states. I've never seen that.
I haven't either,
Okay.
and I've been doing it for 50 years,
So,
and I haven't either.
and even if
And I
we,
came
even if we
back.
agreed with you on the relocation, there'd have to be a time-sharing schedule the other way, and would you want a time-sharing schedule the other way with the child going to North Carolina 3 times a week? I mean, is that in any way in the best interest of the child?
You have 2 parents.
Leave the parents aside. Is that in any way the best interest of the child?
No.
Okay.
And you may even see my motion in there that I came back after she'd made her oral ruling, and I said, Judge, you're mistaken on this. We can't.
That's why we keep asking you if you agree or disagree that we should affirm or reverse on the child.
I think that what should happen is that the relocation should be, this is just not a relocation case.
But even if the relocation, unless Mama moves back to Florida, so let's assume Mom stays in North Carolina and the child relocates back to Florida. All we've done is flip the table. Now the child has to travel to North Carolina to be with Mom. I mean, we've got the same problem, unless Mom moves back, which doesn't seem likely.
What would happen is that the child is brought, I think that when you get to my cross appeal on what's been demonstrated by the mother, I say, if you're going to relocate, then we're denying the relocation of the child and it stays with the father, and you've got to come to Orlando. Is the premise to me of the relocation statute, is a father's not to be deprived. That isn't the way it used to be, and that is the way it is now.
Your view is that all the time sharing would then have to occur in Florida. If we said the
No.
child has to come back, the mom has to visit in Florida.
No. There's things beyond the record here. How you argue
I
it.
want to hear beyond the record.
Right. No. That is not what. I've had this judge to consider these same facts and do entirely different. In fact, I was on the other side, and no summertime for the mother. None. Well, couldn't we have 2 weeks during the summer?
Like I
No.
say, we're interested in this case.
Yeah.
Let's kind of focus here. All right, go ahead.
All right, that's my response was the solution is, and I believe properly, is this relocation shouldn't have happened. She has the money. She's the one. Her basis here is to argue the money. That's her brief, and the court's picking up on the fact that, hey, it's terribly inconvenient. But that's her brief. It is abuse of discretion argument. I don't think it rises to that. And all of his arguments are abuse of discretion, and I don't think it arises to that.
Well, how about the calculation of child support? Did the trial judge use gross income rather than net income? And if so, is that an abuse of discretion issue, or is that a legal error?
First of all, in response, you'll see that the opposing counsel argued there was no guideline child support calculation. That's wrong. Here it is.
Well, that wasn't my question.
Okay. No,
My
but I
question
answered.
was, did the trial judge use gross income or net income?
Net. Take a look at the guideline child support calculation. The number is the same that she wound up with at $313, and it calculates down and uses net income. There it is. What my argument was to her was she didn't take into consideration all the income. It goes on and on and on. We don't know what her income is. They argued, well, they didn't argue, say which tax return you used or something. She presented 2 tax returns. One was joint and one was hers. Which one did they put? She leaves off all the income of the Pump House Studios. She testified that her income consisted solely of rental income and her job, and that was the justification for not taking the full-time job. First of all, the rental income, only she says, makes her $300 a month or something. That's not the case. But then a few pages beyond that, she talks about, oh yeah, well, I had Pump House Studios, and yes, I had $92,000 deposited to that account during that period of time, and she didn't consider all the income. On top of that, she didn't consider the income that she gets from her husband. She owns the house, and there was testimony about this, and she gets $1,000 or more per month from her husband. Not there. She used numbers, and she had a guideline calculation before her, and she used the same number, and the numbers are net numbers. That's how how she got to that number. I didn't agree with it. I thought her income was clearly much higher than what she said, but you win some, you lose some. So that's where it was. The judge did use net numbers, and it's shown exactly here in the amount of child support.
How did you demonstrate that it was in the best interest of the child to change the last name?
Oh, the facts, that's why I think, okay, going to the last name issue. The facts that were in the record, in its entirety, show the best interest of this child, and the judge says it 3 times in her final judgment.
I know what she said. I'm asking you what the evidence was. I mean, I've looked at it, but and I get it where the kid's got to have one or the other under circumstance like
You get
this.
to showing the intent of the mother was to get this husband or get this father out of this child's life. That was at the beginning, and it's evidenced by the fact of the birth certificate. And she did emphasize the birth certificate and her actions of saying, I'm going to let the judge decide 16 months of no visitation, no meaningful time. She leaves his name off the birth certificate. No father shown.
Sir,
Yes, sir.
all of that's true. The
Yes.
question is, how are the best interests of the child enhanced by changing his name?
When the mother takes meaningful steps, as is shown by all the evidence, to deprive the father of meaningful time with his child and to effectively show that really she doesn't want him in this picture. I wasn't successful in that, I didn't think, but
What was
Is
your,
it a sanction then, because she was
No.
a bad person to start with? We're gonna sanction you by changing the kid's name?
no.
Well, then what is it about changing the child's last name that is such a great benefit to the child? Tell us that.
The fact that the mother was trying to get the father out of the picture altogether, and that's one of the tools. That's one of the tools. No name, no, this is my kid. This is Marini, or whatever the child's name was. It was Marini, but whatever the child's name is, it's not your child. You know, she did everything in her power from the day one, from the birth of this child, to get this father out of the picture. And you had a determined father. I don't think I'd have been that determined, but he was. He's saying, I have no money, but I'm going to fight this. I want my child. I really adore this child, and it was meaningful to him. So that's what you had. They had, and that's why I did the statement of facts so long, to show the entire picture. And you have to show abuse of discretion. And the case she cited in the inner order, the facts are almost exactly right, exactly the same. And that's not the McKay decision, the second decision. She cites that case, and so, I mean, you get into, that's Jones versus Roberts, and she cites the case in her order. She says 3 times in her order, in the amended final judgment, best interest of the child, best interest of the child, best interest of the child, in 3 consecutive paragraphs. And she's got a case that backs her up precisely in fact, or not precise, you can't be precise, but very close in facts, and then you come back to abuse of discretion. It was not an abuse of discretion to do this name change, and to make the child, to give the child the father's name, and that does preserve the interest of the father in the child, and that the child knows his father is Kellett, I'm Kellett. That tells you something, and the child will know that. It's not being very successful, but the child knows that. Let me go briefly to the attorney's fees. They keep saying the court didn't have finding of reasonableness or what have you, and I said, first of all, there's an order.
I think it was just the finding of need, not reasonableness, but the finding of need.
All right, there's testimony, there's findings in the case. This is the judge talking. So there is an ability to pay however much, so I awarded attorney's fees based upon the circumstances of the contentious litigation. So there is an ability to pay however much there will be. An ability to pay will be determined based upon the amount of attorney's fee, because I don't even know what the amount is. Next thing, she goes in and says, as far as the assets, is commenting on these financial affidavits.
That's ability to pay. We're talking about need.
Okay.
Need.
Was shown. His net worth.
You're talking still about her assets, her ability to pay.
No. All right.
How about I finish my question?
Yes, sir. I'm sorry.
We're asking you where, there's certainly no statement in the amended final judgment that he has the need. And then we were asking questions of the appellant before, so, you know, that's not a big deal, but it is a big deal. Where is it in terms of a statement in the final judgment, the amended final judgment, or where does the judge talk about need in the record?
You've seen where I took the financial statements of each party and showed what happened to their financial condition. My client's net worth started at, I think, $87,000. At the end, he was worth $30,000, and he did have debt to his attorney, substantial debt to his attorney, and that was there. and it was shown in these financial statements, and I show where her net worth increased, his net worth went down. Down, not just a little bit, he was kind of making $22,000 a year, and he had a net worth of $78,000. And at the end of the rainbow, he has a net worth of $37,000. And so his circumstances diminish substantially from this litigation. Her net worth increased. I mean, that shows you, and that's the evidence before the court, and she says that in another page. This is the court talking. Now, when it comes to the amount, as far as the assets, the ability to pay, either way you look at it, whether I look at her old affidavit, her new affidavit, her net worth is almost $800,000. So, I mean, just looking at that alone is significantly more than Mr. Kellett has, either way you look at it. Okay, so she recognized that one was
She's got more. You're still talking about she has the ability to pay. We're asking you, where is it shown that he has the need? I don't know how to ask it any other way. If you can't tell us, that's fine.
diminishment of net worth, and showed a liability to the attorney. And it was in evidence before the court, and it's truthful. So she did have the evidence before her, and she ruled first. I hate guys that do these shaking glasses around. I don't know how that. I can see you fine, but I can't read fine. She ruled on the attorney's fees, said I'm awarding attorney's fees at the conclusion of the hearing, and then scheduled an entire hearing that went on there's a lot of pages in the record of attorney's fees. And it showed, all the evidence showed this need and showed before the court, and she ruled on those things, signed the order and ruled orally in that findings. Those are on, it always amazes me how appellate courts have their fingers on everything and I don't, but I have the pages of that attorney fee hearing alone was where I had my testimony, the client's testimony, both parties testified, both attorneys testified, and we had the attorney fee records of both parties. Her fees were $70-something thousand, my fees were $52,000.
Okay. Your time is up. Thank you, sir.
Thank you.
Trying to go back in reverse order on what the court just stated. I mean, the trial court in her reasoning for the attorney's fee said, I'm going to award an entitlement to the father for this reason, the fact that the father had no unsupervised visits and had to come to court to get that. So that's why the trial court entered the award of attorney's fees when that's the proper procedure under the statute that mom has sole parental responsibility and the father has to go to court to establish himself as the legal father. And that's his burden under the law. And so it wasn't needed ability to pay. It was the fact that the court perceived that mom was wrong by the father having to go to court to get his unsupervised visitation, to get contact with the child.
As Judge Evander pointed out earlier, though, when we look at the record, there's a significant disparity in their net worth, and there's a significant disparity in their income. Can we, I mean, if the lack of that specific finding doesn't impair our ability to review the appropriateness of the award, can we still affirm it based upon that independent review of the evidence?
I think the court can, but in this case, otherwise the statute requires a finding of need and ability to pay. And there was no finding of need and ability to pay whatsoever, even though.
Is there evidence of need?
I don't think there's evidence of need. I mean, he may have owed his attorney money, but there's also evidence that he had assets that he liquidated at a below market value, spent money on extraneous things. There was a ski trip, the honeymoon, etc. There's numerous things that he spent the money on. So it wasn't that the man was destitute, making minimum wage. So even if you say, well, she had, had assets, well, so did he, and he chose to use them in a different way instead of on his attorney. He gave, I think it was $7,500 back to a relative for their attorney, for their fees in a different case. So there was money there on his part. This is not a thing where he just had the pure need. As far as the change of the child's name, the father, there is no evidence of why it was required for the child's best interest or welfare for this name to be changed. And Dad specifically admitted as such. I mean, he was asked pretty much that direct question as far as, is there any detriment to the child for changing the child's name? No, I just wanted to have the child's name. And to say, well, Dad can still maintain a relationship, have contact with the child, whether there are there are moms that are married that don't have, the same last name as Dad, but they still have a child together. Still knows the child is mom. That doesn't mean they're not going to know this is not who my dad is, or having contact and everything. The child's last name doesn't affect that. The child support calculations were all over the place, and that the time-sharing schedule...
Was gross income used or net income?
I believe it was gross, because the trial court specifically stated she gave gross amounts for child support calculations and not net in 2554 of the record. So we believe she did use the gross and not the net. And that is an incorrect calculation in addition to all the other incorrect calculations as far as not making the proper deductions and proper findings that were made. And go back to the abuse of discretion on the time-sharing schedule. But yes, it is, even counsel in the lower court said, Judge, this is an unreasonable time-sharing schedule. I mean, it's all throughout the record, and at the end, after the ruling was made, yes, this is not in the child's best interest. So I believe the order on all four issues should be reversed and remanded for the court to take the appropriate steps, including allowing the relocation, but fashioning a new time-sharing schedule.
All right, thank you.
Thank you, Honors.
All right, court will be in recess.